Welcome to Accessibility Laws and Trends, the 2026 update. I'm Edward Weiss. It is my pleasure to introduce our speaker today, Matthew S. Kenefick. Matthew S. Kenefick of Jeffer Mangels, Butler, and Mitchell LLP is going to break down the evolving legal landscape of accessibility compliance with a focus on both physical spaces and websites. This program will cover key provisions of the ADA and related California laws, including the Unruh Civil Rights Act and the Disabled Persons Act, and explain how these laws apply to businesses open to the public. It will also highlight how legal obligations intersect with practical considerations in real estate, web development, and consumer-facing operations, offering insight into litigation trends, compliance strategies, and risk management techniques to help businesses avoid costly lawsuits. And now let's get started.
Right. Thank you, Edward. Hello, everybody. My name is Matt Kenefick. I'm a partner at Jeffer Mangels Mitchell. We've done this program a couple years now, and for those who previously attended, I appreciate that. What usually brings us here is not just the general landscape of accessibility laws, but the fact is it's a very hot area of litigation. We saw that trend continue in 2025. We have noted about 10,000 distinct lawsuits filed in 2025 over accessibility. We have California, Florida, and New York are still the top spots for accessibility laws, and we'll talk accessibility lawsuits, and we'll talk about that in a little bit and why that is. We have seen a big increase in Illinois, Chicago specifically. In large part, we believe that that's due to adverse treatment from the New York federal courts. The New York federal courts have been more and more increasingly skeptical of these lawsuits. They've been put a lot of scrutiny. They've been granting motions to dismiss. So we've seen a lot of the New York bar shift over to Illinois, and almost a 10x increase in those lawsuits. Of those lawsuits, of those approximate 10,000, about 20 to 25% of those are specifically digital accessibility, meaning websites or mobile apps, and we'll talk about that. So the litigation landscape is still going heavy. One of the things that's an interesting development is we've seen a big surge in pro se litigations, and estimated up to 40% of these are coming pro se. A lot of people attribute that to the advent of artificial intelligence. AI allows people to very easily take a pre-existing lawsuit or a template lawsuit that's been filed many times before and reuse it for their own personal purposes. So we've seen that too. But with that said, let's go ahead and I have a deck and we'll go through the PowerPoint slideshow here. So let me share my screen here. Okay. So here we are. Just the title page. And so let's start off. We're going to start off with the ADA and the correlating state laws, just the general legal framework. So to give some context, and so you can understand all sides of the perspective here, the ADA is a civil rights law. It's, ADA is the acronym for the Americans with Disabilities Act of 1990. It's intended to afford individuals with disabilities rights similar to those without disabilities. And the protections are, they extend to all different contexts, from public accommodations to employment to transportation, even state and local government. The idea is historically persons with disabilities had a hard time participating in society one way or the other, right? There's challenges to living with disabilities, and a lot of people do. estimated 25% of our population has disabilities. And those disabilities could be cognitive, they could be physical, there could be a lot of different ways it manifests. And those disabilities can make it challenging for the individuals to participate in society. And the ADA is intended to help overcome that, make society more welcoming for persons with disabilities. Because it is a remedial statute intended to remedy prior bad acts, conduct, whatever you want to call it, where society, has been less inaccessible. It's broadly construed. Remedial statutes are broadly construed, meaning that they're going to, courts are supposed to round up in favor of access, so to say. The intention is to provide guidelines to enable the full and equal provision of access. The idea is if people know what to do, they can do it. And as we'll talk about it, those guidelines are not so clear on some things, but they are clear on others. So we have different sections of the ADA, Title I through Title V. Title I is employment. Title II is public services, state and local governments. Title III, public accommodations. Title IV, telecommunications. Title V is miscellaneous provisions. We're going to focus on Title III, public accommodations. So what is a public accommodation? It's pretty much any place that does business with the public. So we have examples listed here, and these are right out of the statute. You've got places of lodging like hotels. You got restaurants, food service establishments, entertainment venues such as theaters, stadiums, auditoriums, convention centers, bakeries, grocery stores, clothing stores, pretty much any retail place. That goes on to see the next bullet point. It gives some examples, whether it's a laundromat or a bank or whatever. We have public transportation terminals, depots, museums, galleries, zoos, nurseries, daycare centers, gyms, health spas, bowling alleys. You get the point. It's intended to be places that are generally open to the public. This can become an area of contention. We have seen the argument over website access, whether or not a pure internet facility is a place of public accommodation. We also see this with private clubs or private businesses that are sometimes opened to the public and then turned into a place of public accommodation. So what is required? When we're looking at physical access, so physical access, means something that you would think of generally as, when you think of somebody who has mobility disabilities, somebody who may use an assistive device such as a wheelchair, walker, cane. For physical access, if you have a new construction facility, it must comply with all new construction standards. And that is important because the ADA, as we talked, 1990, we have effective dates of either January 26, 1991 or 93, depending on the facility. So we have pre-existing facilities, and we'll talk about that. But for new construction, you need to comply with the Americans with Disabilities Act accessibility guidelines or accessibility standards. One is the 1991 standards, one is the 2010 standards. But these are very clear federal standards. They're memorialized in the Code of Federal Regulations. You can find them. They'll give you very specific guidance on dimensions, tolerances, things that you're supposed to do. You also see there's Title 24, the California Building Code referenced here. That's important to note because California has its own laws, the Unruh Civil Rights Act, and you have to comply with the California laws. And Title 24 sometimes is a little bit different than the than the Americans Disability Act accessibility guidelines or accessibility standards. And so you have to comply with the stricter of the two standards. We see this in some, like I said, there's some interesting things. California uses a different type of braille. We have westernized braille in California. California transactional counter heights can be different. California ATM locations and scoping can be a little different. So this new construction standard also applies to alterations, and that can be an area of dispute as well. An alteration is a modification which affects usability of the feature. And so you could have an argument if I re-slurry a parking lot, is that an alteration? Well, you're changing the striping, right? Because the striping is going to be covered. So is that an alteration? That's a co-triggering alteration. But certainly if you do just a slurry, are you going to have to change the slope on it that would have come from the paving? So the scope of the alterations can be an area of dispute. The standard is you're supposed to remediate the entire altered element. Again, these are flexible subjective terms intended to allow judicial discretion. You must remove access barriers where readily achievable. So that's the second standard. And this applies to pre-existing facilities. So these are places that were constructed prior to the ADA. And what that means is you don't have to tear down a whole building to make it accessible. We see this a lot. There's a lot of legacy buildings, depending on the location. Usually it's out of state, where we see a lot of buildings that are built up on a foundation that's above the sidewalk, presumably for drainage or snow. And so you have a built-in set of stairs right into the sidewalk. And you may not have the room to put a ramp in place. So the question is it, are you required to tear down that whole facility, raise the facility and get rid of the raised foundation and make it street level for the purposes of achieving access? And the argument, of course, is that's not readily achievable. Readily achievable is something that can be accomplished without great difficulty or expense, does take into consideration safety and security. That does come into play sometimes. So what would you do by way of example? In the case of a legacy pre-existing facility that has a built-in set of stairs, a ramp, the basic, with not a ramp, but a set of stairs, a step up that you're not able to overcome without tearing down the facility. Well, you look at either putting a wheelchair lift in. Some places have done that. That's generally pretty expensive, but we have seen that a lot in New York. You can put a portable ramp. You can use a portable ramp with a sign that says, look, let us know, and we'll either with a phone number or a call button that's prominently placed, so a person with disabilities will know that's the accessible route and they can go there. Or alternatively, you could have an alternative entrance. As long as you have clear signage, it's not circuitous, you're not sending them 3 blocks around a building to get in, but something that provides equivalent facilitation. When it's not readily achievable, then you can look at what's called an equivalent facilitation. So we also see that another standard that we have in the ADA is policies, procedures, and practices. And this is kind of the catch-all. And this is public accommodations have to make reasonable modifications in their policies, practices, and procedures to afford equal access. And so when you find something that's not specifically enumerated in the code, we'll often see enforcement agencies like the Department of Justice or private individual enforcers who are plaintiffs. We'll see them rely on this and say, look, you need to modify your policy. There's a lot of examples of this. There is some precedent that the the modification not only needs to be reasonable, that the patron must request it. That's a Ninth Circuit precedent. But yeah, this is a catch-all, and you can see this just in about any application. So another area of the ADA is auxiliary aids and services. And basically what it is, at no charge, public accommodation must provide auxiliary aids and services to achieve effective communication. The public accommodation gets to decide what those auxiliary aids and services are, but you need to achieve effective communication. Examples could be a Braille statement, qualified interpreters at events, note takers, video displays, screen reader software, magnification software, etc. We usually see this come up as a backup argument on website access, but I've had class actions over all kinds of different layers like this. There was one that was sweeping New York for a while. It was about Braille credit cards, or gift cards rather. Gift cards. They wanted to have some type of way for persons with visual disabilities or who are blind to be able to check their statement balance or know who to contact for customer service. So this is an auxiliary aid and service component. We have seen this come up in several different contexts. So the next one is the California laws. I mentioned earlier, we have California laws. They're specific to access. We have the Unruh Civil Rights Act and the Disabled Persons Act. The Unruh Civil Rights Act incorporates ADA as a violation of the Unruh Act. However, a lot of it, for those attorneys who immediately think when they get a lawsuit under 51F, which is an Unruh Act violation triggered by an ADA case. If you're in the Central District, be caution about removing it. Check your judge. Some judges have rejected that as being a basis for removing a state court case to federal. And that obviously, you don't want to do a removal if there's if that particular judge is going to reject it, you might end up having some adverse consequences. Unlike the ADA, which does not provide a private plaintiff damages, you can get plenty of fines, penalties, and damages from Department of Justice. But the ADA, the monetary recovery, is limited to attorney's fees. Unlike that, the Unruh Civil Rights Act provides $4,000 minimum per incident statutory damages for physical access, not communicative access, but physical access cases. There is a requirement that the plaintiff shows difficulty, discomfort, or embarrassment, or a deterred visit, meaning that they would have went to the place of public accommodation, but for their knowledge of the barriers. That's the requisite threshold to achieve these statutory damages. There's a couple other roadblocks they put up for small businesses, facilities that have been CASP inspected, certified access specialist inspected, but this is the primary standard. There are some cases out there that have held that difficulty, discomfort, or embarrassment is a little bit higher of standard. They have to show some type of physical or emotional injury more than just encountering the facility. We've had some judges who have found that even though a plaintiff has encountered a barrier, they were still able to achieve access, and therefore the requisite damages components present. But again, you could imagine how these $4,000 per incident statutory damages make a very big threat on a class basis. I've handled and worked on some class actions that have had very significant damage claims and resolved for 8-figure amounts based upon the presence of these statutory damages. And the Unruh Civil Rights Act does require mitigation of damages, both specifically under the codes applicable to accessibility, but also in general. Case law precedent does require that. Um, the the Disabled Persons Act, and I'll just make a comment about it. It's actually it's a less than politically correct named of a of a statute. Um, the way the vernacular, the terminology that's preferred is persons with disabilities, meaning that the disability doesn't define the person, but that's our law. So Disabled Persons Act, it's $1,000 statutory damages, so a little bit less. Very, very, very less frequently used because there's a California Supreme Court case that found that the fee shifting clause in it is bilateral, whereas under Civil Rights Act and ADA, the fee shifting clause is viewed as a component of damages. Disabled Persons Act, there's a case that holds that it's bilateral, meaning that in that case, the defendant successfully established that it wasn't readily achievable to remove the stair that the plaintiff was suing over, and they got defensive attorney's fees. So we talked about the building code, and there's a delta between the federal and the state standards. We'll see that we look at the building code, which is title or section 11B of Title 24 of the California Building Code. That's updated triannually. So, unlike the ADAG or the federal standards, which are not regularly updated, the building code is. Like I said, there are some distinctions between the California standards and the federal standards. And unlike the federal standards, which has the readily achievable requirement, the building code does not. You've heard the term grandfathering. That does apply to building codes. So if you have a permit that you obtained, the building code at time of achieving of that permit is what applies. Again, if you alter the element, then you have to bring it up to current code. So the UNRRA Act is broader in that it applies to business establishments, not public accommodations. And business establishments can be in the broadest sense possible. For those real estate lawyers, it does apply to the sale and rental of housing. Similarly, the UNRRA Act does have a broader definition of disability, whereas the federal standard for the ADA requires a substantial limitation on daily life activity. The UNRRA Act does not require that. It's just a limitation on daily life activity. So I mentioned website access. So we'll talk about visual accessibility on websites. So many jurisdictions find that websites are places of public accommodation. Prior to the Target case, which my recollection was 2009, most courts did not consider a website to be a place of public accommodation. And in fact, in 2001, I published as the editor, not as the author, a publication article about website access, and we didn't look anything at the federal standards. We looked at FCC regs because it was understood back then that they weren't looking at the ADA. There are different jurisdictions that hold different things. Some jurisdictions hold that pure websites, internet-only websites have no physical presence, are not public accommodations. Some jurisdictions, the courts hold that pure internet websites are public accommodations. Some jurisdictions require that the website that needs to have some type of nexus with a physical or public accommodation that's in brick or mortar. It could be, by way of example, a store locator listed on a website. It could be something as simple as, selling advertising the products or giving coupons for that facility. But that's the nexus that some jurisdictions require. A lot of the state laws we're talking about that impose statutory damages, they are bootstrapped into the website access. We have seen the Department of Justice say that the standards that they like to see achieved are the Web Content Accessibility Guidelines, WCAG, and there's different standards. That they have 2.2 is the current conceptual one. 2.1 is one of the most acting ones. There's success criteria factors, A, AA, AAA, A being the most lenient, AAA being the most stringent. AA is what most people go for. If you go to AAA, it reduces a lot of the functionality of the website. So we see a lot of website claims. I just mentioned at the beginning of this. 20 to 25% of the new filings are website claims, and it's an easy explanation. They're really easy to file. For a physical facility, you're supposed to go to the physical place and encounter the barrier. At least that's what's required to confer Article 3 standing for the injury in fact under Lujan versus Defenders of the Wildlife. But a website, you don't have to leave your house. You just have to go to a website. We have for a physical facility, you can imagine all these measurements that people need to take, need to figure out what's there. They have to often send out some type of architect to look at or an expert to figure out, what are some of the nuanced violations. But for a website, they can just use an automated program to test the facility or the website. But the interesting thing is the automated tests really are not the true standard of access. We don't have a formal adoption of the WCAG. We had the Ninth Circuit say that it can be used as compelling evidence of noncompliance, and also a court can compel a public accommodation to remediate to that standard under its equitable jurisdiction. But other than Title II, we don't really have a wholesale adoption of WCAG, and in part because WCAG is conceptual in some regards. So what is usually the gold standard on whether something is accessible is use case testing. Actual persons with disabilities using the websites, using their assistive technologies, screen reader technologies, etc., in the way that they ordinarily would, and use the website. They can use it that, with or without the WCAG compliance. That tells you whether or not it's usable. There's some people who will say, look, you comply with WCAG, but I still have problems using your website. There's some people who can't use a website or can use a website that's not WCAG compliant. So it's an issue. Now, one of the things that we do see that makes a very easy target is the fact that a lot of people use templates for their websites. They use common development teams. So you can imagine you have one company with multiple brands. All those brands probably have similar website development templates. They probably have the same developer. If it's in-house, probably the same back office team or the same outside developer. And the fact is that makes a really easy target. If you know a company has multiple sites, you find one problem, it's probably on all their sites. And now as a plaintiff, you can sue all those different companies, which is why when I settle cases for those types of companies, I insist on two things. First, I insist on an enterprise-wide release. I want the plaintiff to give us an entire release. And if we're doing it in New York, I want it to be future claims too, because under New York law, you can't get a release of future claims. But the other thing is I want to notice an opportunity to cure. If this plaintiff believes that there's anything wrong with our enterprise in the future, I want a warning shot. Some plaintiffs will, or some defense attorneys rather, will request, and some plaintiffs will give a representation from plaintiffs' counsel about no other pending lawsuits. That's up to you on your comfort level. But everybody knows it's a violation of professional rules to impair the ability of another attorney to represent their clients. So I have seen in the past some plaintiffs' attorneys would offer protection. They'd say, look, you just hire me as your consultant on a going forward basis, and then I'm conflicted out and I can never sue you. And we've had professional responsibility opinions looked at this that said you can't do indirectly what you can't do directly. And I have seen and represented some people who have had those agreements come to light with some federal judges who weren't very happy about them. So we talk about claims having bootstrap damage claims. That's an issue. One of the things that makes it difficult is anybody who services retail clients, they know that often we'll have code lock during the holiday season, meaning that if you get a claim during November or December, maybe even October, about the website, you're probably not going to be able to make any repairs to that website until the end of the holiday season. They do not want people interfering with the ability. The retailers do not want people interfering, especially compliance lawyers, interfering with the ability for those websites to generate revenue. Holiday seasons can be very important. So another issue is, people who get third-party content, some content's deep linked, some content's licensed. You could imagine a payment processing component. Those things, that can be an issue if it's not compliant. So Doctor, mentions here public-facing website access policies. We like to have, and we'll talk about this a little bit. We like to have policies that face the public, that say, look, this is our policy. This is what we care about. And if you have any problems, here's a channel of communication to let us know what's wrong with our website. The reason that's important is I've reviewed just about every consent judgment that justice has required over the years related to website access, and they always want a public-facing policy. And one of the first things I've seen when the Department of Justice has made any investigatory inquiries about website access is they say, we want to know about all the complaints you've received over the years. What type of things are people complaining about with regard to your websites and your usability, your communicative policies. And it's really hard for you to prove a negative. But if you have a dedicated communication channel and you preserve all incoming complaints, and you have no complaints or a very small amount, that's how you prove the negative. You say, look, we have 300 million interactions per year on this particular website. Of those, we believe 800, or 80%, just pick a random number, XYZ% are unique users. And we only have 3 complaints, something like that. That's compelling evidence that a lot of people are using your website and not having a problem. One of the things, of course, is you got to make sure that the points of contact are also compliant with law. We'll talk about that in a little bit because you get in trouble over that. Then remedial access vendors. There are companies out there that will help you bring your website into accessibility compliance. A lot of developers they have accessibility training. Historically, they did not, so we relied really heavily on these third-party vendors, but that has changed. That has changed a lot. We talked about the WCAG. It comes from the World Wide Web Consortium. It's a voluntary standard at this point, but a lot of courts use this as a as a benchmark, most plaintiffs do as well. It focuses on perceivability, operability, understandability, and robustness on the content. Again, we're looking at people are using assistive technologies to to access the website. So what would we think of as assistive technology? Screen readers like JAWS by way of example. So imagine somebody who is blind at navigating a website. They're not able to use the graphic interface. They can't use a mouse. So how do they navigate the website? Well, they use it with their keyboard, often using the tab function or the arrow keys, and they will go from heading to heading to substructure to substructure. They have software that will read to them what's on those headings, what's describing them. We'll talk about some of these features in a little bit. And those types of features are how people interact. So what you can do yourself is certainly you can hire somebody to check your website, or just wait until somebody sues you and check out and get their report. But you could also check it yourself. Here are some free tools to do an automated test. These are starting points. It's not going to be comprehensive. There are some more comprehensive ones out there, but manual testing is always recommended. So we talked about some of these website features. So we said the heading structure, right? So heading structure is really important for people to navigate using a screen reader. Easy way for people to get lost is or stuck is a bad heading. So another one is alternative text. So what is that? Alt text is a descriptive set of invisible text for images. So by way of example, if I was shopping for women's shoes and I'm scrolling over an item and it's described by a heading, but then when I go to the item itself, it just says shoe. That's not going to be very descriptive. It's not going to tell me what's there. But you could have alternative text. It could say black woman's, pump with a leather upper and sequins, or whatever would be the 3-inch, whatever would be the meaningful text to be able to allow people to navigate the website. Now, certainly, if it's in the description of the item, the alternative text can be duplicative. So there is a level of judgment call there. But a lot of people get popped on alt text, and the reason being is you have a lot of items. You have a lot of items on your website, and one of the things that gets changed a lot often are the images. So it's the updates. It may be developed in compliant, but it gets updated and it's not kept in compliance. And the alt text is one of the things that gets updated a lot. Color contrast is something that we see a lot of. A high contrast would be something like my slide here, a dark black on a white background. But if you look at the watermark on the bottom of here, it has our firm branding and the date. That's low contrast. That's a gray on white. That's not going to be accessible. And this is not for somebody who uses screen reader technology. It's for somebody who's low vision. We see a lot of claim for there are blind individuals asserting color contrast claims. Certainly it doesn't apply if you're blind. You're not going to be noticing a color contrast issue. But again, that's just the sloppiness on the plaintiff's bar. Again, we talk about navigability with the keyboard. The captioning is something that's really important. So if you have pre-recorded video that has sound, you should have captions on that. Now, live, it's optional. It's recommended that for live content that you're not going to, if you don't have any captioning, that you put a statement, look, there's no captioning, but you don't have to. And certainly, again, if the captioning is duplicative, what's in the content of the website itself, and it's easily ascertained, then then there's a good argument that you don't need the captioning, and there are some comments about that. These are just some of the common barriers we see that are addressed in claims. Again, you can, if you're worried about website claims, what you can certainly do is you can hire a website consultant to help you check. You could do your own regular checking yourself. Anytime you have new content, it's really important to make sure that that new content is compliant, and we, obviously provide training, for people who are involved in this, a culture of compliance. I've seen some people come up with development guidelines for internal development staff. Again, you can create whatever infrastructure you like to try to achieve accessibility depending on the priority it is for your company or your client's company. One of the things that we have seen that is helpful is making sure there is one person who has ultimate ownership of accessibility. It looks good from an optics perspective. It also helps make sure things get done. Another thing we like to do is, we have templates, and you got to make sure those templates are accessible. Otherwise, you really got a problem. You could have all your websites have the same problems because you have one bad template. Some of the pitfalls, software overlays. So one of the very marketable things is, look, you could just pay a company to put a software overlay on your website, and they'll tell you that it'll make it accessible and screen reader compliant, and you'll never get sued again. The reality is the technology is good, but it's not there yet, and a lot of plaintiffs target websites specifically that use overlays, in part because they want to discourage people from relying on the overlays. Because if people have a quick and easy, cheap fix, they're not going to get sued as much. But also because there's a lot of criticism over the overlays not working. If you are using third-party companies for the website templates or their or for their embedded or deep link content, you should watch out for that. That's an easy way to getting in trouble. Remember, you talked about alt text, we talked about keyboard navigation, color contrast. I mentioned earlier about captioning for pre-recorded content. This is the standard on that, the WCAG 1.2.2. Again, it just goes through that. You need to have some type of captioning for pre-recorded content, or you risk getting sued. There were a lot of suits over this for a while. We saw a lot of it over certain types of websites. First, one wave was they hit all the resorts, because resorts always have nice videos. The next one was plastic surgeons. Or cosmetic surgeons. So there you go. Another thing to keep in mind is it's not just the website, it's other content. So if you have PDFs, by way of example, embedded, those should be accessible. Otherwise, people are going and they're seeing the PDFs and they're not able to use their screen reader. We talked about policies. Policies are very important to achieve an infrastructure. It's also a good defensible mechanism. I think that if you can come up with a good policy and you can onboard and train off of it, keep it in your learning management system, you're going to have a higher chance of achieving access. And then also you'll have a good defense in the event that something does go wrong. So we like to have them consistent. We like to have channels for customers or visitors to make accommodation requests or complaints. We like to have interaction etiquette policies so people know how to interact with persons with disabilities, because it's really easy to upset people, especially some people are very sensitive about their situation. So, so we look at service and emotional support animals. This is a hot topic. Um, so first it jumps out. This is from last year, but it's still relevant. We had somebody who filed a lawsuit over over a realtor not allowing a service animal in an open house, and they asserted a series of claims. So it's something that should be on people's radar. So what is a service animal? So a service animal, this is the federal standard, um, is any dog or miniature horse. Miniature horse is federal. State is just dog that is individually trained to perform tasks for the benefit of a person with a disability. The training component is a matter of controversy. Certainly, the professional trainers all say, look, you can't do self-training. A lot of people do believe that they can do self-training, but I've been at these conferences. You can tell the difference between a professional trained and a self-trained service animal and the way they conduct themselves and the services they provide. So what is not a service animal? An emotional support animal. Now, while as a landlord, you may be required following an interactive process to allow somebody to take a emotional support animal into in their individual dwelling or place of work. That's not for the public accommodation. Emotional support animal is just an animal that provides comfort, right? But it's not individually trained and doesn't perform tasks. And obviously, that's a hyperbolic picture of a very adorable Yorkshire Terrier and a purse. So we talk about under the California law, guide dogs, signal dogs, service dogs, the ADA law, dogs and miniature horses. The problem is you can't really challenge this without without getting it right. If you challenge somebody who has a service animal and say that's not a service animal and kick them out, and you're wrong, you get in trouble. So what can you ask? Is you're not allowed to really inquire into the nature of the disability. So you can ask whether the guest needs the animal because of disability, but that's it. You can ask what tasks they have been trained to perform, but you can't ask for proof of training or a license. You can't ask them to verify or explain their disability. You can't charge a pet fee or cleaning charge. Now, you may charge for actual damage, and certainly a violent animal or animal that's not under the control of its handler can be removed. The practical matter is you consider putting, if you're public accommodation, some type of formal written statement regarding your service animal policy that complies with the laws. You should probably discourage your employees from having any of this dialogue, because either A, they're going to get something wrong, or B, the guest is going to say they got something wrong, and now you have a lawsuit over he said, she said. It's not worth it. It's a problem. So I stay away from that. It is worth noting that it is a misdemeanor to represent an animal as a service animal when it's not one. We see this all the time. People go online and they get a service dog, license or vest or whatever. There is no license. There's no registry. A trained service animal is a very special animal. It's the breeds are very, very well selected, finest stock. For the dogs to actually make it to actually the training, it's some of the trainers I've talked to, it's like 30 or 40% max. A lot of the dogs, they just don't have the temperament. So you have the right temperament, you have the right type of animal, and then they have special training. And they can be an amazing thing. They really can. It's unfortunate that some people try to take advantage and misrepresent that their animal is a service dog when it's not, just because they want to be near their pet. And I get it. Look, pets are wonderful, but sometimes they're not meant for all locations. And again, an emotional support animal, comfort animals not trained, but keep in mind, under Fair Housing Act laws, you may need to allow individuals with disabilities to have an emotional support animal. We have jokes about what that means because it could be, your emotional support chicken or snake or whatever. But that's a housing non-public accommodation issue, and that's the FEHA or the Fair Housing Act. It's not a ADA issue. Um, so what do lawyers do? How do you respond to claims? Just the same as all other claims. First you're going to investigate. You'll identify all the barriers. I like to look at when I get an accessibility claim, I do two tracks. Track one, triage, put out the fire. Track two, concurrently, make sure we don't get sued again. So we investigate the claims. We're going to identify all the barriers. We're going to see what type of protections exist. These are small businesses I mentioned. If you're a small business, you get certain types of time from notice of the claim to remove the barriers. Small businesses are defined for certain types of number of employees and revenue. CAS, Certified Access Specialist Program, certified by the Division of State Architect. We look at that and we look to see if you have a CASP certification. Again, that might be a reduction in damages. And we look to see if it's new construction and permitted after January 1st, 2008. Another one of these exemptions could limit damages. You got to make sure your client knows, do not retaliate if the plaintiff returns. I've seen this happen. Plaintiff comes back and the individuals working at the facility or own the facility say, you're not welcome here. Don't do that. Do not do that. You got to know the rules. A lot of courts have special rules for accessibility cases. Northern District, California has General Order 56, by way of example, puts the case on stay, and then you have to jump through a bunch of hoops before you can actually litigate. Similarly, Central District, you have the ability to get an early neutral evaluation and a stay if you elect to that. You got to pick your battles wisely. There is a prevalent plaintiff attorney's fees clause. A lot of these plaintiff's attorneys, they welcome a fight because you are going to just drive up their fees. So you have to know who you're dealing with. If it's one of these serial litigants who has a high volume model, you may want to consider a deterrence factor of defending the case a little before settling, because you will disrupt their business model. But again, I wouldn't do that for the first claim. If you're dealing with the fifth or sixth claim from that firm, you may want to talk about that with your client. Obviously, prepare for future suits. Been sued once, it's public record. Odds are you're going to get in the line of fire again. One of the key things is these plaintiffs do circulate between law firms, so something to know. So make sure when you get the release, it protects you, on a going forward basis to the extent you can from that same plaintiff, because they may, even if the plaintiff's attorney may not sue you again, they may switch to a different plaintiff's attorney. Similarly, that same plaintiff's attorney may switch to a different plaintiff. We like to talk about creating an accessibility strategy. The accessibility strategy, again, we want to identify compliance issues, deficiencies, any type of issues that we have, common conditions which cause lawsuits, quickly identify and prioritize action items. We like that, like I said, we like the policies, practices, and procedures. You start with the policies, then you train off of those. That creates the practices, and you give people the procedures on what to do. The practices, of course, is how they implement those procedures. Again, I do like the customer-facing policy aspects. Prioritization, some things are going to be easy to fix. You can imagine at a public accommodation, signage, directional signage telling people how to get around. Whereas you could see a complete structural change could be something that would be very difficult to deal with. I like to, obviously we want to do the action plan, rapid deployment of the quick wins, all the normal stuff. One thing to remember is for certain types of remedial work, You do have some type of tax incentive um, credits, tax credits up to a certain amount for certain types of businesses. So, it's always good to have somebody look at this from a tax perspective, because you may very well find that your client could have a tax credit for some of the work they're doing. And so that's the end of the slideshow, folks, and we can switch to the Q&A. Me.
Alrighty, Matthew, we actually have quite a bit of questions. So starting us off, we have John Dominic Vitiello asks, where can practitioners find reasonable web access experts? Unlike CASP, there is no license associated with web access, and accordingly, there's no public portal for finding experts.
Yeah, that is a big challenge we all face. The first thing to do, of course, is to start with your existing development team. Who's working on your websites? Who's done the back end? Who's done the work? Talk to them, find out what they have is with regard to their ability to do website accessibility. You'd be surprised. Sometimes your existing resources have that. Second of all, certainly with the engagement, I've been involved with the engagement on those accessibility or a lot of those development people with respect of accessibility many times. You got to make sure that the scope of engagement initially does in fact cover access. They need to know that that's part of their scope of work. You can imagine you have a foreign developer who works in multiple different jurisdictions. They may not appreciate your needs in the States. So you got to make sure that they know that. And then certainly contractually, you can come up with some protections. With regard to the developers, again, there are some remedial folks out there. The problem is the big companies like DayQ. They're there, but they're still very expensive. And often they're not going to be able to be as well versed in the specific nature of the website you're looking for. So again, we talked about, by way of example, you have there was a bunch of websites related to resorts that got hit. Well, there was a team of folks who did the resort websites. They were really good, and they all had a very similar feel to it. And you want to make sure you have somebody specific to that. So I would think it's just like any expert. You're going to want to tailor it to the size of the client. If it's a smaller client, it's going to be obviously a smaller engagement. If it's a larger client, then certainly you're going to want something with more resources. You're going to want to look at somebody who has the capability to deal with the different types of content. Some people have different content than others, right? And then finally, of course, we're going to want to look at the cost budget. And obviously nobody wants to pay more, but sometimes there's going to be some cost limitations. So I wish there was a silver bullet answer, but unfortunately, I have yet to find a standard, reliable web development resource. Usually, it's one-off. I mean, I have a couple people who I like, and you're more than welcome to email me, and I'll send that to me. Send you some contact information directly. But I haven't found any specific general omnibus resource on that.
All right. And then on a similar topic, I'm just going to skip ahead to this question. What percentage of accessibility lawsuits did you say at the beginning of the webinar correspond to digital spaces?
Yeah, it's tough to keep track of all of them because a lot of lawsuits are filed in the state court, and those are not tracked as well. But it's estimated 20 to 25% on the data I have seen. Now, the interesting thing is that doesn't take into consideration demand letters. We get, I can tell you, for every lawsuit I get from my clients, I have 10 demand letters. And how you deal with the demand letters, really depends on the client. Sometimes, sometimes that these people are sending out mass demand letters, and it's a wait and see. Let them come back. Wait till they knock twice. Sometimes they go away. But it's a case by case basis. and that doesn't track all of, all the demand letters. But 20 to 25% is what the resources I've seen. I've seen statistics say more, I've seen less, but again, that's the general statistics I've seen.
Great, thank you. And then Erica Rudin asks, do municipalities have a duty to provide city parking, or could a municipality theoretically eliminate all city parking and shift the burden to provide any parking at all, including for disabled people, to private entities? If there is a duty for a municipality to provide access to the cities via city parking, what is that authority? Thank you.
Yeah, I apologize. I don't know with regard to parking obligations for a municipality in general, whether or not they have to provide it or not. I suspect it'd probably be something you would see in the general plan for each city. But again, I'm not a land use lawyer. I guarantee the Beverly Hills Bar Association has a tremendous list of people who are land use attorneys, some of which are at my firm. I'd be more than happy to make an introduction, but I don't know that. But I do know that there are guidelines with regard to scoping as to when parking is provided, how many accessible spots. There's a formula based upon the number of spots, the locations where they need to be. And that's one of the good things about the federal standards and also the building code standards for physical access is you do get some very specific, precise guidance as to what is and isn't accessible. And so that helps you comply. If you want to do the right thing, there's a lot of guidance there. And when there is some ambiguity, and there is ambiguity out there, there's generally some guidance on that as well. On communicative access, digital access, it's less than clear, especially given that technology changes. You can imagine how many people now use a mobile device as their primary way to access the internet compared to 5 years ago, 10 years ago. And the mobile devices add a whole nother component, whether it's app or mobile content. And then you also have different assistive technologies on your mobile device. You're not using the same JAWS screen reader technology as on your desktop computer as you are on your iPhone, right? So it does change a lot. But again, I just don't know the circle back and close the loop. I don't know what is the obligation of a municipality to provide parking, whether they have to or they do not.
All right, and then I have a question here. The private enforcers for reasonable accommodation will file suit for it when does the private enforcer become a vexatious litigant?
Yeah, that's a very good question. So, I mean, certainly we have our standards for vexatious litigant, right? And we've seen that. We've seen that a lot. Anybody who's been in the court, you've either encountered one or you've seen the judges deal with one. But generally speaking, for lawsuits related to accessibility, California has standards. If you file more than a certain amount, I believe it's 10 within a certain period of time, you become what's called a high frequency litigant. And a high frequency litigant has to pay an additional filing fee. Again, this relates to physical access. You have to pay an additional filing fee. You have to register with the Judicial Council, I believe, your complaints and lawsuits. You can't, if you send a demand letter, there's some limitations on that, and you're supposed to include some materials in that. So there are some ways of dealing with that for a high frequency litigant. We've all heard about it. Some really bad practices where we've had people where the lawyers would go out and manufacture the lawsuits, and those lawyers have been disbarred over it, where they would go to facilities, either driving the person with who's the plaintiff with them to these facilities solely on a trip to manufacture lawsuits, We've seen some that weren't, that didn't have that, that were where they weren't even with the plaintiff. Certainly, when you get to a situation like that, you go into tester standing, which of course is very controversial. Most jurisdictions do not favor tester standing for Article 3 purposes. But there are plaintiffs, pro se litigants, who literally, and I've litigated against them, who literally will go on a road trip and they'll hit 10, 15 different facilities on the road trip. And some of these places will be 500 miles from their home. And they come back and they sue them all. I've had one where a guy stayed at like 3 or 4 different hotels in 2 days. He hit 3 or 4 of the same brand retailer in 2 days, each one 100, 200, 300 miles apart from each other. It was clearly the manufacturer. It was clearly to manufacture a lawsuit.
Okay. So we have another question here from Travis Chow asking, are you seeing law firm websites being targeted by these types of claims? Guessing website.
I have. And we've also seen law firms historically the subject of some Department of Justice enforcement. So one of the things that we talked about was communicative access. So one of the about 10 years ago or so, telephone relay services was very popular, TRS. I've talked about this in our prior webinars. And what TRS is if I have a difficulty or disability in speaking or hearing, I'm not going to use a traditional telephonic channel to communicate, right? I'm going to either use a text message, a chat, maybe a teletype device, which is a special device that basically acts like a chat device. And that's how I'm going to communicate. And so through the FCC, through 711, they have, of no charge to U.S. residents, they have a program where you can call up either by text or video chat, so you can sign language, or teletype a communications assistant. That communications assistant will then pick up the phone and call the recipient of that. That communications assistant, it's they're not the client. So we had a lot of banks in trouble with this, and some law firms, where they would say, look, I'm not going to speak to this communications assistant. This is confidential financial information, private attorney-client information. I'm not going to talk to this communications assistant. I want to talk to the actual client themselves. And that's a violation of law. And a lot of banks got hit over that. A lot of companies got hit over that. And a lot of law firms got hit over that. And Department of Justice did assess penalties. I think the largest one that I saw was a $20 million fund, and that was to Wells Fargo. And I did make a comment earlier about when you have a complaint channel or an accommodation channel on your website or on your company, to make sure that people can actually communicate with you. I was referring to accepting teletype devices and TRS calls, because you could imagine if you tell somebody with a disability, look, you have a complaint, you can call us here. But what if that person can't hear? What if that person can't use a regular telephonic channel? Then they're limited to either using a teletype device, which you should accept, the TTY calls, or a TRS call, which you should accept.
Great, thank you. And let's see. So I have Lan asking, what is the accommodation for a deaf or blind person on a website?
Okay, so I don't know if that is a a person who's deaf and blind, but a person who's deaf, certainly it would be the captioning for video content. And then through any telephonic communication channels, either TTY or TRS. For blind, again, we want to make it compliant with the assistive technology, the screen reader technology, which would generally be we would aim towards a web content accessibility guidelines or a WCAG standard on that.
Great, thank you. And then Robert Aronoff asks, what are the rights of a service animal over an emotional support animal?
Hey, Robert, good to hear from you. And the so well, certainly you can take a service animal into any place of public accommodation, subject to reasonable guidelines. There's if there are health and safety issues, there are some. We have seen some situations where, by way of example, it may not be safe to bring a dog into a pool or something like that. We have situations like that, but for the most part, as a service animal, you're entitled to go to the same place as the person with a disability. They're allowed to come in. And again, a service animal has to be under control of their handler. We say handler because keep in mind the person with disability may not be the person handling that service animal. They have to behave. They have to, not pose a direct threat. And if they do, then certainly, then they can be asked to leave. Emotional support animal, under the ADA, it's treated as a pet. And you're subject to all the other restrictions that a pet may have. But again, under FEHA or FHA, you could get either at your workplace or your residence, you could get you can engage in the interactive process to try to get the emotional support animal permitted, which is, you make the request, you demonstrate some type of need, you have the interactive process, you both work together collaboratively to figure out whether or not it's reasonably necessary for your access. But that, again, that's a housing, not a public accommodation inquiry.
Great. And it looks like we just have one question from Robert Weinstock. Are you aware of any changes to laws such as providing defendants with an opportunity to cure before litigation can proceed?
Well, last year there was Assembly Bill 1474, something like that. There was an Assembly bill that went last year that got through the state Senate, and it's on the next step. Certainly, the lobbyists will know what the next step is. But there is a California bill that was passed to try to give a notice and opportunity to cure. That has not, it's in legislative purgatory right now. It hasn't been passed. But and that was restricted to, I believe, small businesses to give them an opportunity. But there are some protections you can get. And I try to cram this presentation into 1 hour, and I could obviously talk about this a lot longer. But there are some things I did not talk about, and one of the things is the protections that you have as a small business. By way of example, you do have an opportunity to cure, and if you do that, it'll reduce the statutory damages, I believe, from $4,000 to $2,000. If you have that's just my recollection, I have to look at the statute again. Then similarly, if you have a CASP inspected facility and it's been certified to meet all applicable standards and nothing has changed to an element since the time of the facility being inspected, and the plaintiff is suing over the element, you likewise have a period of time to fix and remediate it after getting notice of the claim, and that too stands to reduce the amount of statutory damages. So, but otherwise, the notice and cure component has, it's been a very controversial subject. People have been trying to get that in place for a long time. And it really just balances, the whole public need versus the statutory framework. The idea, I hear from both sides. The idea is, look, small businesses and big businesses are being extorted by plaintiffs firms who are making all the money. These persons with disabilities, really are just being shills in this money-making scheme. That's not my words. That's the words from a case. I can't. Yeah, was it Molsky? I think that's the Molsky case. But there was a case where one of the, I think it was Judge Rafiti, described, the money-making scheme of the plaintiff's attorneys using the plaintiffs as a shill. But so you hear that, but and being close to the world of persons with disabilities, I know you do not want to put a lot of money into the hands of a person with legitimate disabilities, such as a big monetary reward from a lawsuit, because that could compromise their ability to obtain much needed state benefits, whether it's whether it's Medi-Cal or IHSS or regional center benefits, all the different things that these people significantly rely upon. So the money's going to the plaintiff's attorney. So you go, well, that's really bad. We're just basically, legalize extortion. But the flip side of that coin that we hear is, look, there's too many public accommodations out there to be enforced and patrolled. So what needs to happen is you need to have an incentive for plaintiffs' attorneys to go out and do this. And the fact that they're acting as extortionists is scare tactics to bully people and to proactively do whatever they can to try to get rid of the risk of lawsuits. So that's the juxtaposed positions.
All right, Matthew, it looks like we have one last question. Do we have the time for this?
Yeah, absolutely.
All right. So Joseph Cole is asking, does a certificate of compliance from a web access expert provide a defense to a class action lawsuit by a blind tester?
Well, it's interesting that's an interesting defense because I've encountered this a lot over the years, and procedurally, it depends on the jurisdiction. So, in my experience, certainly compliance is the standard, and if you can demonstrate compliance, then you have the benefit of getting rid of the case, right? So how can a plaintiff sue if they don't have a remedial benefit? How are you going to prosecute a plaintiff's claim for federal ADA when injunctive is all available and there's no injunction available, right? And that's we often find that you just moot out barriers, and that disposes of the case. These from a federal component, from an injunctive class action. Keep in mind, a lot of the class actions move forward on damages alone. And so that would be, when the website was not compliant, did people have damages? But so the issue is if you're going to attack that, one of the ways you could attack it, certainly would be under a 12b1 if it's in federal court, right? Lack of subject matter jurisdiction. You can't. The claim is moot. There's nothing for the court to enjoin. There's no remedial benefit. They lose subject matter jurisdiction. The issue that you face in some jurisdictions, such as the Ninth, is when the merits of the claim are inextricably intertwined with the jurisdictional facts. The court does not require the plaintiff to demonstrate that there is subject matter jurisdiction. So it's kind of a catch-22 because you're attacking the merits, but you're also attacking the jurisdictional elements. And under the Ninth Circuit, some judges will not apply that standard. Again, you can try to do it by doing a summary judgment and hope that the other side doesn't provide competing evidence. But otherwise, mootness is the defense, but it can be challenging because of that, the Ninth Circuit standard on that. That said, I've gotten a lot of 12B1s granted over the years. I've seen them granted in a lot of different jurisdictions. So, but I think that's the last of our questions, and I really do appreciate the engaged participation here. Sorry I didn't have all the answers to all the questions, but definitely some great stuff to look at.
Great. Well, this concludes today's presentation. Thank you so much, Matthew, for an excellent presentation. And thank you so much to our audience. Have a great day, everybody.
All right, take care.